Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Commonwealth versus Peterson. This case was heard in the Supreme Court of Virginia in the year of 2013. Let's go ahead and jump into the facts of the case. Plaintiff is Peterson, the defendant is Commonwealth, the state of Virginia. The plaintiff and defendant are swapped in the naming of the case because the plaintiff had won in the appellate court and then the state appealed it to the Supreme Court. So the plaintiff is the estate of two individuals that were murdered at the Virginia Tech mass shooting in 2007. So there was a mass shooting in 2007. There was a gunman on Virginia Tech campus, pretty tragic. A lot of people remember it. It was all over the news. He opened fire, killed a few individuals, very sadly. And two of the individuals that were killed brought a suit against the state of Virginia and against Virginia Tech University, claiming that Virginia Tech University had a duty to warn the students on campus about the gunman. So there's an event that transpired prior to the mass shooting, and in a dormitory there was a domestic, what looked to be to police officers, a domestic shooting. One individual was shot, there was wounded, and they couldn't find the suspect, right? And this was early in the morning. There was a bunch of blood, there was a trail of blood. At this point in time, the police officers in Virginia Tech knew that what they had thought was a domestic violence incident had occurred. What was about to transpire was a much larger mass shooting. The police of Virginia Tech, the institution, didn't know, they didn't believe, they didn't foresee that a mass shooting was going to take place, so they didn't warn the rest of the students on campus, like, hey, there's a gunman that's around campus. They didn't warn them about it. And so what the plaintiffs in this case are trying to allege is that Virginia Tech, when they knew that someone had been shot on campus, they had a duty to warn all of the students on campus about an open gunfire, and the danger that was going to be there on campus. The court has to grapple with this. It's really sad. It would be nice to see some monetary damages for these plaintiffs. The court has to decide, are we really going to allow these plaintiffs to recover from the state through this institution? And it's a novel argument, and the court relies heavily upon a doctrine in the restatement that says there's no duty to warn third parties of danger that's coming, right? That's not a duty that the law of torts is going to prescribe a lot. So when it does, there has to be a special relationship between the defendants and the plaintiffs, right? So the court says we're going to assume that a special relationship exists here. So that we're going to assume that because there's a special relationship between the students and the institution of Virginia Tech, that there would be a duty to warn of foreseeable harms. Now, where the court is going to say that the argument of the plaintiffs fails is that the harm wasn't foreseeable by the university at that point in time. They had just thought, the police officers, the detectives, folks over there had just thought that incident was a domestic violence incident. It wasn't a mass shooting, wasn't the precursor to a mass shooting. So the court says it wasn't foreseeable by the university that a mass shooting was going to occur. Therefore, even if there was a duty because of a special relationship, that duty wasn't full because you only have a duty to warn, and even with the special relationship, of foreseeable harms to foreseeable plaintiffs, right? So court rules in favor of Virginia Tech and the state of Virginia, and that's the case. Let's go ahead and jump into some ex ante discussion. I think that this case might come out differently in 2020 than it did in 2013. I think that might be because of universities' access to all their students now, right? Universities have so much more access to their students via email blasts, via text messages, because they have all the students' phone numbers oftentimes. And just share a personal experience, when I was attending undergraduate at the University of Utah, there was one night where I got a blast on my text message that says, "We believe an active gunman is on campus. Shelter in place, be careful." And I think that's what Peterson and the plaintiffs would have just wanted. Maybe just a text, an email, something over the loudspeaker saying, hey, there's an active gunman on campus. Now, foreseeability is interesting, right? Someone was murdered in a domestic violence incident, which looked to be, but it really was just the precursor to a mass shooting. Should there be a duty of universities whenever someone is shot, whether it looks like a domestic violence, whatever it looks like, should there be a duty to warn all those students? And I think that in the year 2020, a court could have come out very differently on this. So that just because even if there's just been one gunshot, there's a duty to warn, right? We might not know that there's going to be a mass shooting, but there might be a duty to warn. I think that has evolved over the past 13 years since 2007, 7 years since the ruling, because of the more and more mass shootings that we've sadly seen in our society. And because we're seeing more and more of these events, they might be more and more foreseeable, especially after one gunshot or one person has been injured. And it might, prescribe a duty on these universities to warn all of their students. So sad case, that's the discussion of it. Hope you enjoyed the video though. If you'd like to see more, go ahead and hit the subscribe button, and I hope you have a great rest of your day. Bye-bye.